Okay, well, we're going to talk a little bit about bankruptcy here today for a few minutes, and want to point out that I've noticed in some of the discussions that we've been having that there's been some really good points on there, and I want you to look at Reese's discussion board where she puts up the Pre-Petition Counseling. I think that's a very, I do that I think every time. This is very important, I think, and I think you ought to give it a good look. Pre-Petition Counseling, because she found some websites on there that you can do counseling online, or you can even do it on the telephone. And some of it is also nonprofit. So it says on there that it's $30, but it also says that you can apply for fee waiver. Okay? So, and that's what you get a lot of times with these nonprofits is opportunities for fee waiver. Okay? So that's a pretty good find on Reese's part. Excellent job, and I want to share that with everybody on the discussion. If you're not paying too much attention, she's just right above me on one of the discussions where I posted earlier on the pre-petition counseling. Now this particular discussion, let's say virtual lecture, is going to be on bankruptcy research checklist. So let me kind of launch into this. It goes into the different kinds of bankruptcy codes, historical and revision notes, federal rules of bankruptcy procedure, local rules including United States trustee guidelines, federal rules of civil procedure, plus the federal rules of evidence, bankruptcy reporter systems, bankruptcy treatises. So these are all sources that you could use, and so that's something that's well worth the time to look into it. So one of the things you want to consider is that bankruptcy research and where you would go to look things up. Now consider this, that for example, I'm going to give you an example. You need to think about some of these cases where research is important, and one of them, let's give for example, and this has actually happened to me. Let's see, the man and wife, they go through divorce first, and then the man files bankruptcy. I think that's bad. I think that's a mistake. I think if you're contemplating divorce and you think you're going to need to file bankruptcy, it would be wise to file a bankruptcy file a bankruptcy first as man and wife, so you can file it jointly. You save money that way, and then file the divorce second, because you've cleaned up your financial mess before you ever get into the divorce court. Well, what ended up happening is they had these court orders that the husband was supposed to pay for the house. I think in his mind the whole time he was thinking he was going to file bankruptcy, and really it put the screws to the wife, literally, because she ended up having to pay the mortgage, even though the court order in the divorce said that he has to pay the mortgage. So the problem with that is, and I've talked about this with you before, is when you get into a situation where it's like a triangle if you think of it. Okay, you've got the man, you've got the wife, and you got the bank. Okay, So try and think of it all that way, okay? So the divorce court makes a ruling, but it's only here, okay? So as to the bank, they don't recognize that divorce. That has no bearing on them. They were not, the bank's not a party to the divorce, okay? So that's a very compelling point, okay? So the man cuts off the bank by going through bankruptcy. So what does that leave? Well, even though the divorce court said that the man has to pay the mortgage, the woman ends up having to pay the mortgage. So what's her choice? Well, she can either take that house and pay the mortgage, or she can file bankruptcy. Okay? Everybody with me? So, I mean, that's the problem that you get stuck with. But the problem you get into, you got 2 attorney fees, you got 2 filing fees, any other expenses that are related to it, he pays. Well, then over here, it's all duplicated. So if you're halfway smart, you know, even though you hate each other, you know, why give extra money to lawyers, clerks, all this type stuff. And expenses, that would include that pre-petition counseling, you know, all those different kinds of things. So these are things to consider when you're looking at this from a research standpoint. So be careful on that. Okay, so another thing is I want to talk a little bit about bankruptcy preparers. And bankruptcy preparers, this is a very touchy area in Indiana, okay? So whenever, I don't know if you know this, but you figure out, but whenever I put B/R, that equals bankruptcy, okay? So, from now on. And then another one that I use a lot of times is defendant. And this one is plaintiff, okay? This is just common stuff we learned in law school, these many years ago, okay? So try to shorten it up when you're just writing notes and things like that. But if we're looking at what we call a bankruptcy preparer, then that would be something like this, okay? And the problem that you can get into on this is, in Indiana we still have the unauthorized practice of law. It's an A misdemeanor, and that means you can get 1 year in jail for engaging in the unauthorized practice of law. Well, fortunately for bankruptcy preparers, that is a federal law. So to the extent that you follow that federal law carefully, you can be a bankruptcy preparer without being an attorney, okay? But you've got to be very careful. You can never use, for example, anything like legal advice, or this bankruptcy petition is legal. It's legal to use a bankruptcy preparer. You cannot use the word legal anywhere in it, okay? Never use the word legal, okay? Very important, okay? Never advertise in any legal category. Never, never, never. Like if there's an attorney section, you never want to be anywhere close to that if you would decide to become a bankruptcy preparer. Also cannot receive payment for court fees. Lawyers accept money for filing fees because they in turn file it with the court in turn allows them. They actually, when I was doing this, I actually had a debit card set up that I put a little bit of money in, like $400 or $500, so I would never be overdrawn. And then when the client came in, the fee was like $150. The client would give me a check for $150. I put it in that debit card account. That's the only one in there was filing fees, filing fees, filing fees. Don't commingle money if you're working for another lawyer into that filing fee account, because you'll get it all screwed up. Likewise, bankruptcy petition preparers cannot accept filing fees the way that a lawyer can. So that hampers you a great deal in terms of doing electronic bankruptcy. You about have to be a lawyer in order to do that. But when you prepare, what you prepare is actual printed bankruptcy forms that people in turn have to take to the court themselves, because a bankruptcy preparer can prepare the papers, but they cannot practice in the courthouse. And that even includes they cannot file papers unless they work for a lawyer. Okay? So no lawyer involved in the case, no filing in the courts. Okay? That's another important thing. So, that's a pretty big deal. 10 days after filing a petition, you still have a duty to file with the bankruptcy court a declaration under penalty of perjury disclosing fees paid or promised by or on behalf of the debtor. So even though you're just a bankruptcy preparer, you still have to file the document about fees. Only it's not attorney fees, it's bankruptcy preparer fees, okay? Also, preparers must sign the documents and include your name and address on any bankruptcy petition that you prepare. Also, you have to provide a notice to the debtor, and you should keep a copy of that shows that you are not allowed to give legal advice, okay? And also prepare a social security number, has to be on the document. Sometimes now some of the courts are allowing you to shorten that to the last four. Also furnish the debtor with a copy of the document no later than the time the document is presented for the debtor's signature. Okay, so that's important. So those are some 8 basic requirements for bankruptcy preparers. So that's, I think, pretty important stuff. So give that a look. We talked a little bit about means testing in the past. And I talked a little bit about that pre-petition counseling, like I said earlier. Basically important stuff. Well, next time we get back together, we'll talk a little bit about bankruptcy appeals. So hang in there. Hope you enjoyed this little bit of a virtual lecture. And be sure and follow up and do what I said about checking out those websites on the pre-petition counseling. I think that could be useful to you in your career. So, see you next time. We'll try to give you some more interesting observations. Thank you.